Assalamualaikum warahmatullahi Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Norbaya Maini. So for my part, I will discuss the law governing the main contract between the Global Miner Consortium Limited and Nusantara Resources Sdn Bhd. So in this case, the issue is whether the main contract is governed by the transnational commercial law as expressly chosen by the parties, or whether Malaysian law should apply because the project has a substantial connection with the Malaysia. So as a general rule, the governing law of contract is determined by the principle of party autonomy. This means that the parties are free to choose the law that will govern their contractual relationship. So Malaysian court is generally respect such choices. For example, in Putrajaya Holding case, the court recognized that the importance of party autonomy in arbitration. Similarly, in Vita Food case, the Privy Council had that an express choice of governing law should generally be upheld as long as it is in good faith and it is not contrary to public policy. However, party autonomy is not limited. It's not unlimited because under Section 4, Clause 1 of Arbitration Act 2005, it is stated that arbitration cannot operate in a manner that is contrary to public policy. Therefore, mandatory domestic law may still apply even where party have chosen a different governing law. Applying this principle to the fact, Clause 26 expressly state that the agreement shall be governed by the transnational commercial law, international trade usage, and general principle of law recognized recognized by the civilized nation. So this clearly shows that the parties intended to use a natural legal framework instead of the law of any specific country, because Global Miner would argue that this choice is appropriate because the transaction is highly international because the negotiation took place in Dubai. Financing arrangement involved in Switzerland. The agreement was signed in Singapore, and the mineral was supplied to buyers in Japan and South Korea. However, Nusantara can argue that the contract is closely connected to Malaysia because the extraction and processing of the mineral were carried out in Malaysia. So the extraction and processing of the mineral were carried out in Malaysia, and then the operational license were issued in Malaysia. No, the operational license were issued by Malaysian authorities, and then the alleged environmental pollution, labor issues, and displacement of fishing communities are also occurred in Malaysia. So importantly, the agreement itself requires the compliance with the environmental, labor, land, public safety laws of the host state, which is Malaysia itself. So this indicates that the parties recognize that Malaysian law will continue govern important operational aspect of the project. Therefore, Nusantara may argue that although transnational commercial law govern the overall contractual relationship, but also issue relating to environmental compliance, labor right, public safety, regulatory approval remain subject to the Malaysian law. So to conclude that the main contract is primarily governed by the transnational commercial law, but also because it is based on the party express choice and the principle of the party autonomy. Nevertheless, this does not exclude the application of mandatory Malaysian law, especially where the dispute concern activity that carry out in Malaysia and matters that affecting the public interest. Thank you.
Assalamualaikum and good day everyone. I will discuss about the second issue. The first issue is whether the arbitration agreement is governed by English law or by another legal system, such as Malaysian law. So the rules to this issue is with the doctrine of the separability. Under this doctrine, an arbitration agreement is legally independent from the main contract. It means that even the substantive contract is governed by one legal system, the arbitration agreement may be governed by the another. So the purpose of this doctrine is to preserve the validity and the enforceability of the arbitration agreement, even if dispute arise that concerning the main contract. In Malaysia, this principle is reflected under Section 18 of the Arbitration Act 2005. This section recognizes the arbitral tribunal's power to determine its own jurisdiction. So the next step is to determine whether the parties have expressly chosen the governing law of the arbitration agreement. In this case, Clause 26 of the contract states that the arbitration agreement shall be governed by English law. So, under the principle of the parties, an express choice of governing law is generally respected by the arbitral tribunals unless exceptional circumstances exist. So, where parties have expressly selected the governing law, the choice will normally prevail. When there is no express choice, the court will consider whether an implied choice can be inferred. And this approach was established in the case of Sulamerica Cia Nacional de Segurosa against Enisa against Hariasa, where the court introduced a three-stage test. The first stage is to determine whether there is an express choice of law. Second stage is there is none. Then it will determine whether there is an implied choice. Finally, if neither exists, so the court will apply the law with the clauses and the most real connection. And this approach also later affirmed by the case of Inca Insat Versanai AS against Russia Investment Limited, where the UK Supreme Court confirmed that an express choice always takes priority. So the doctrine of the implied choice is only relevant where the parties have remained silent regarding the governing law. While for next is the significance of the seat of arbitration. So in this case, the London is as the seat of arbitration. The seat of arbitration is much more than physical location where hearings are conducted. It is the juridical home of the arbitration. So for the determination of the seat arbitration, it will first determine about the procedural law, which is known as the LAD4163. Secondly, it determines which court have supervisory jurisdiction over the arbitration. Thirdly, it determines which court has authority to hear the application to set aside an arbitral award. And lastly, it was to determine that the extent of judicial assistance during the arbitration proceeding. So, under Section 22 of Arbitration Act 2005, it reflects also the Article 20 of the Unilateral Model Law, which parties are free to choose the seat of arbitration. And this importance of the seat arbitration was illustrated in the case of Navira Amazonica Peruana SA against Compañía Internacional de Seguros de Peru, where the court held that the London referred to the juridical seat of arbitration rather than merely the venue for the hearings. Also, it was similar to the case Thai Lao Lignite Company Limited and another against government of the Lao People's Democratic Republic, where the Malaysian court affirmed that the only courts of the seat have supervisory jurisdiction over the arbitration proceeding. So for the application, applying to the principle to the present case, Nusantara may initially argue that Malaysian law should govern because the concession project, environmental incident and regulatory action all took place in Malaysia. However, this argument is stronger in relation to the substantive obligation under the main contract rather than the arbitration agreement itself. So for the arbitration agreement, Nusantara is unlikely to succeed because the party expressly agreed that English law governs the arbitration agreement. It was also applied to the case of Selamreka and Eka, where the tribunal is required to give effect to this express choice. So there is no need to consider an implied choice of law. Accordingly, Nusantara should avoid challenging the governing law of the arbitration agreement because such challenge has very limited prospect of success. Instead, Nusantara's stronger legal strategy is to accept that English law governs the arbitration agreement while arguing that the substantive dispute remains subject to Malaysia's mandatory environmental, labour and public law requirement. Although the doctrine of implied choice remains legally relevant, it only provides the framework for cases where the parties have not expressly selected the governing law. So, since the party choose English law, there is no need to infer an implied choice in this case. For the conclusion, uh, the choice of London, Nusantara should accept that English law governs the arbitration agreement and instead of focus its legal argument on ensuring that the substantive dispute remains subject to Malaysia mandatory environmental and public law requirements. That's all from me. Thank you.
Hello, my name is Siti Lukman. My metric number is 1222061. Okay, so move on to the second issue, which whether mandatory Malaysian law and public policy relating to the environmental protection, labour rights and human rights can override or limit party autonomy in international arbitration. Okay, so party autonomy is recognized as the cornerstone of international arbitration because it gives the parties the freedom to determine how their dispute will be resolved, which include choosing the governing law, arbitral rules, languages, arbitrators, and the seat of arbitration. And also, Malaysia adopted this principle under the Arbitration Act 2005, which is based on UN Central Model Law. Specifically, Section 8 limits the judicial intervention except where expressly provided under the Act. So, this reflects Malaysia's pro-arbitration approach and respect the parties' contractual choices. However, party autonomy is not absolute, and it remains subject to mandatory laws and the public policies of the country where enforcement is sought. Firstly, Section 30 of the Arbitration Act 2005 allows parties to choose the substantive law which governing their dispute. So in this case, the global minor relies on clause 26, which provides that the agreement is governed by transnational commercial law, while the arbitration agreement is governed by English law. However, the contract also expressly stated that all operational activities must comply with the environmental, labour, land and public safety law of the host state, which is Malaysia. So therefore, Nusantara can argue that although the parties exercise their autonomy to choose transnational principles, they also agreed that Malaysian mandatory laws would govern the project operation. Therefore, the tribunal failure to consider those mandatory laws was not an exercise of party autonomy, but rather a failure to give effect to the parties' own contractual agreement. Secondly, Section 4, Subsection 1 of the Arbitration Act 2005 provide that dispute may be referred to the arbitration unless the arbitration agreement is contrary to the public policy. So in this case, the dispute is not merely a commercial disagreement, but it involves allegation of environmental contamination, forced displacement, exploitative labor practices, and violation of human rights. So these issues not only affecting the contractual parties, but also affecting Malaysian public as a whole. So accordingly, Nusantara can argue that these matters engage important public interest, which cannot simply be excluded through private agreement or by relying solely on transnational commercial law. Furthermore, when deciding whether to enforce an arbitral award, Malaysian court adopt a very narrow approach to the public policy in order to respect the validity of arbitration. So this principle was established in the case of PT Asuransi, Jasa Indonesia, and Dexia Bank, where the court held that intervention is only justified if enforcing such award would shock the conscience, be clearly injurious to the public good, or violate the most basic notion of morality and justice. So, applying this principle in the present case, the tribunal exclude evidence relating to human rights reports and community impact assessment, stating that those matters fell outside the scope of commercial law. Commercial arbitration. However, these issues were precisely led Malaysian government to suspend that project. So Nusantara can argue that enforcing such award connected or related with environmental harm, forced displacement, and unsafe labor condition, which would contrary to the Malaysian fundamental values of justice and public welfare. Finally, Section 39, Subsection 1, Paragraph B, Subparagraph 2 of the Arbitration Act 2005 allow the Malaysian High Court to refuse recognition or enforcement of an arbitral award if it is contrary to the Malaysian public policy. So, this principle was reaffirmed in the case of Master Mulia Sdn Bhd and Sigur Rus Sdn Bhd, so which held that public policy extends to the situation where it involves fundamental injustice or illegality. So, in applying this case, the unlawful retention of the migrant workers' passport constitute a clear breach of Malaysian law. Yet the tribunal awarded damages without properly assessing or considering these mandatory legal breaches. So, therefore, Nusantara can argue that enforcing such award would undermine Malaysia's regulatory framework and effectively penalize compliance with Malaysian law. So, in conclusion, while party autonomy remains a fundamental feature of international arbitration, but it is not absolute. So, in the case where an arbitral award is contrary to the Malaysian law or Malaysian public policy, then the court has power to intervene in such award. So, accordingly, Nusantara has a very strong grounds to argue that Malaysian High Court should refuse to reinforce such award under the Section 39 of the Arbitration Act 2005. So, I believe that's all from me. Thank you.
My name is Nur Amira binti Nur Hasni and my metric number is 1222060. I will continue the presentation by explaining the issue on whether the arbitral proceedings between Nusantara Resources and Global Mining Consortium complied with the principles of natural justice and the right to be heard, despite Nusantara's absence during a crucial stage of the arbitration, which allegedly denied it a reasonable opportunity to present its defense. So first and foremost, under the Arbitration Act 2005, Malaysian courts adopt a non-interventionist approach towards arbitral awards. However, they may remain committed to protecting procedural fairness. So Section 20 of the Arbitration Act 2005 requires that parties be treated with equality and that each party be given a reasonable opportunity to present its case. This reflects the fundamental rule of natural justice, which is audi alterum partem, which guarantees every party the right to a fair hearing before a decision affecting its rights is made. In addition, Section 37 provides that an arbitral award may be set aside, specifically under subsection 1, paragraph B2, where the award is in conflict with public policy, and subsection 2, paragraph B1, where there is a breach of natural justice during the arbitral proceedings. Similarly, Section 39, subsection 1, paragraph A4 allows the court to refuse enforcement of a foreign arbitral award where the affected party proves that it was unable to present its case. Furthermore, the leading Malaysian authority on this issue is Master Mulia Sdn Bhd and Sigur Rus Sdn Bhd, decided in 2020. So in this case, the federal court established a 4-stage test for determining whether a breach of natural justice justifies setting aside an arbitral award. So the court considers which rule of the natural justice was breached, how the breach occurred, whether the breach was connected to the making of the award, and finally, whether the breach was sufficiently serious to affect the outcome of the arbitration. Nevertheless, Malaysian courts impose a high threshold before interfering with arbitral awards, and therefore, not every procedural irregularity will justify setting aside an award. So, applying these principles to the present case, Nusantara requested an adjournment because its key witnesses were unavailable due to ongoing domestic investigations. Despite this reasonable explanation, the tribunal rejected the request and proceeded with a critical evidentiary hearing in Nusantara's absence. More importantly, during that hearing, Global Miner was permitted to introduce new expert reports and witnesses' testimony on causation and damages. As Nusantara was absent, it had no opportunity to challenge this new evidence, cross-examine the witnesses, or present evidence in response. So these matters were directly relevant to the tribunal's final decision. So this clearly undermined the requirement under Section 20 that both parties be given an equal and reasonable opportunity to present their case. And as a result, Nusantara may rely on Section 37 to argue that the award conflicts with Malaysian policy because the proceedings involved a serious breach of natural justice. Furthermore, applying the Master Mulia framework, Nusantara can demonstrate that the breach had direct impact on the outcome of the arbitration. Had the adjournment been granted, Nusantara would have been able to present evidence showing that the operational disruptions were caused by mandatory regulatory interventions by the Malaysian authorities and by independent subcontractors beyond its control. Such evidence could have significantly weakened or even defeated Global Miner's allegations that Nusantara had breached the contract. To add, although Malaysian courts are generally reluctant to set aside arbitral awards, this case involves more than a minor procedural defect. The tribunal proceeded with a crucial hearing in Nusantara's absence while simultaneously admitting fresh evidence that Nusantara had no opportunity to challenge. So this amounts to a substantial denial of the right to be heard and satisfied the high threshold established by Malaysian courts. In conclusion, the arbitral proceedings did not comply with principles of natural justice or the right to be heard, and by refusing Nusantara's request for an adjournment and proceeding with a critical hearing in its absence, the tribunal denied Nusantara a reasonable opportunity to present its defense. Consequently, Nusantara has strong grounds under the Arbitration Act 2005 to seek to set aside or resist the enforcement of the arbitral award on the basis of a serious breach of natural justice. Thank you.
My name is Nur Azza Amisha binti Azmi. My metric number is 122064, and today I will present issue D, which is the issue is whether Nusantara Resources may successfully resist the recognition and enforcement of London Arbitral Award in the court under Arbitration Act 2005 and the New York Convention, and what specific grounds are available based on the tribunal. Okay, now we move to the section which is the rules. Okay, Section 38 provides a smooth mechanism to turn an arbitral award into a binding court judgment. On the other hand, Section 39 outlines the specific exhaustive grounds where the High Court must refuse to enforce an award. So as a general rule, Malaysia could prefer a pro-enforcement stance. This means the court wants to respect the finality of arbitration and a principle supported by cases like TNB Fuel Services and Telekom Malaysia against LGB Engineering. The court sets a very high threshold to reject an award. However, this pro-enforcement rule is strictly subject to the fairness requirement under Section 39. So if a party can prove a serious breach, such as being unable to present their case, the tribunal exceeding its scope, or a violation of public policy, so the court has a duty to refuse enforcement. So today, we will argue that Nusantara satisfied these strict grounds. So now let's look at our first ground, which is the procedural unfairness. So the sub-issue here is whether Nusantara was denied its fundamental right to be heard. So the rules are clear because Section 20 of the Act mandates that both parties must be treated with absolute equality and given a full opportunity to present their case. If this is breached, Section 39 subsection 1, paragraph A, subparagraph 2 provide a direct statutory ground to refuse enforcement because the party was unable to present its case. So this principle of natural justice is heavily backed by the case of Front Row Investment Holding and Daimler. So let us apply this to our case. So the tribunal's conduct was completely unfair because Nusantara's key witnesses were legally required to attend mandatory domestic government investigation, but Nusantara asked for a short adjournment, and but the tribunal rejected it and held a critical evidentiary hearing in our absence. So to make matters worse, during that hearing, the tribunal allowed Global Miner to introduce brand new expert reports on causation and damages. Because Nusantara was absent, we could not cross-examine their expert or respond to the new evidence. This is a textbook violation of Section 20 and Section 39, giving Nusantara a rock-solid ground to resist enforcement. Okay, now finally let's address public policy, which is excess of scope, and our conclusion. So for public policy, the rule under Section 39 subsection 1 paragraph B subparagraph 2 states that an award cannot be enforced if it conflicts with Malaysian public policy. So the case of AGT and AJU confirm that an award can be set aside if it violates the mandatory law of the place of performance. So applying this, the contract explicitly require all operations to follow Malaysian environmental and labour laws. So the tribunal bypassed this by wrongly labelling these laws as non-commercial, and environmental protection and citizen safety are mandatory statutory right in Malaysia. So enforcing an award that ignores our sovereign's law is directly against the public interest. So next, for excess of scope under Section 39 subsection 1 paragraph A subparagraph 4, the rule established in the Hemofarm case states that a tribunal cannot rule on matter outside the arbitration agreement. By refusing to look at human right and community impact assessment, which were legally tied to the contract, the tribunal failed to resolve the actual dispute and exceeded the mandate. So for the conclusion, while the Malaysian court maintains a high threshold for finality, the combination of a severe denial of natural justice, a violation of public policy, and an excess of scope provides Nusantara researchers with robust winning argument. Nusantara should immediately file an application in the Malaysian High Court to successfully resist the recognition and enforcement of this award. So that's all from me. Thank you.